In the matter of ESAKKIMUTHU versus State represented by Inspector of Police, Supreme Court allowed the appeals and questioned set aside impugned judgment dated 10th September 2024 passed by Madras High Court as well as trial court's judgment dated 4th March 2020. Appellants were acquitted of charges alleged against them and were accordingly ordered to be released. The case involves two accused persons, Pichu Mani @Pichai Mani and Esaki Muthu accused 2. As per prosecution story, PW1 Moses Livingston, son of deceased Edison Suvi Seda Muthu, was a resident of South Omanalur village in Tirunelveli district and was de facto complainant in the matter. Both accused persons were also residents of same village. Deceased used to know Balasubramaniam, father of A1, and in July 2011, deceased was informed to jurisdictional police by said Balasubramaniam. This had given rise to feud between two parties and led the deceased to attack Balasubramaniam, who sustained injuries on left hand due to the said attack. Ongoing enmity had precisely been ascribed to be motive of by the prosecution behind murder of deceased by appellants A1 being son of Balasubramaniam and A2 being relative of A1. It was further stated by family members of deceased who disposed as PW1 and PW2 Santhi, wife of deceased, that deceased was a habitual drunkard and had several cases against him. In fact, deceased was detained under Tamil Nadu Gundas Act 1982 and was released from prison merely 2 months prior to incident. It was case of prosecution that on day of incident, that is on 14th of April at in 2013 at around 12 noon, A2 went over to residence of deceased and asked him to accompany to a Tasmac shop for consuming alcohol. Deceased and A2 left for said purpose on A2's motorcycle. PW1 and 2 were at home and knew about deceased's departure with A2. However, it was alleged that they grew suspicious of A2's conduct and decided to reach the said Tasmac shop in order to bring back deceased. It was essential to note that thereafter P1 and 2 claimed to have left their residence on bicycle, reached said shop from south entrance of shop, saw deceased person sitting and drinking with A2. At that time, A2 is said to have administered a threat to deceased, gave a signal towards north entrance of shop, calling out A1 and asking him to finish off deceased, whereupon A1 appeared and started attacking deceased indiscriminately with a weapon by way of retaliation to injuries caused to Balasubramaniam by deceased in the past. Supreme Court said that, firstly, it seems absurd to presume that distance was less than almost 16 kilometers when PW1 had himself deposed and agreed about said distance range. Further, in opinion of the Supreme Court, appellants had rightly raised contention regarding improbability of PW1 and 2 covering 16-kilometer distance in matter of 30 minutes on single bicycle. Even after affording due consideration to factors like anxious state of mind, it seemed highly unlikely that boy of 17 years could be able to cover such a long distance with his middle-aged mother as a pillion rider. It was prosecution's own account that deceased had left house with A2 at 12 noon on motorcycle and incident took place at around 12:30 p.m. This leaves PW1 and PW2 with a bare period of 30 minutes to reach the place of occurrence, encounter the deceased over there and subsequently witness horrific incident. It seemed exceedingly improbable and raises huge doubts about presence of PW1 and 2 at the crime spot. Once their presence at the scene becomes immensely doubtful, it renders entire prosecution story highly unbelievable and lacks any substantial evidence about appellant's involvement in the crime. Said occurrence was described to take place at 12:30 p.m., having allegedly been witnessed by PW1 and 2. Two accused persons escaped from crime spot and deceased succumbed to multiple injuries at spot itself. Additionally, it also remained highly questionable as to why after incident two eyewitnesses travelled back to entire distance of 16 kilometers to house first and went to police station only subsequently thereafter, despite there being a police station en route from the liquor shop to their home. No satisfactory answer to such loopholes in the prosecution story had been provided by the star witnesses. Therefore, court said that it becomes clear that even though heavy reliance has been placed by courts below on the testimonies of PW1 and 2 in this case to bring home guilt of accused persons, their presence at place of crime in itself is highly contentious and cannot be said to be proven definitely. This improbability gains even more prominence in light of fact that no other alleged eyewitness had supported prosecution's case. These alleged eyewitnesses, including PW4 and 5, who were customers at Tasmac shop, and PW6, who was manager, and having been declared hostile by prosecution, these eyewitnesses during deposition had stated that 4 or 5 persons came and attacked the deceased. Postmortem report identified 26 injuries on the body of the deceased, which in the facts and circumstances of case are unlikely to be caused by sole assailant and is more probable to be a result of attack by a group of individuals. The fact that deceased was a habitual drunkard and a convicted criminal under the Gundas Act make it highly probable that deceased had enmities with the multiple people who may have assaulted him and caused his death. It cannot be said that prosecution had discharged its burden of establishing guilt of accused persons beyond reasonable doubt. In such circumstances, accused persons have to be declared innocent, and there is no alternative to such a conclusion.